Hi everyone, this is Tarkazi Chaudhary on behalf of Lamantar presenting the latest judgment of Supreme Court on Section 497 of IPC. Supreme Court strikes down adultery as an offence. Highlights: Chief Justice of India Deepak Mishra said adultery can be a ground for divorce but not a criminal offence. Justice D.Y. Chandrachud called adultery offence as a relic of past and said Section 497 is destructive of women's dignity and self-respect as it treats women as a cattle of husband. The Supreme Court on Thursday declared as unconstitutional the panel provision on adultery, saying it was manifestly arbitrary and rents the individuality of women. A five-judge constitution bench was unanimous in holding Section 497 of the Indian Penal Code dealing with the offence of adultery as unconstitutional and struck down the penal provision. The bench comprising Chief Justice Deepak Mishra and Justices R.M. Nariman, A.M. Khanwilkar, D.Y. Chandrachud and Indu Malhotra held that Section 497 is unconstitutional. The CJI and Justice Khanwilkar said, "We declare Section 497 of IPC and Section 198 of CRPC dealing with prosecution of offences against marriage and unconstitutional." CJI, here I am going to highlight some of the important points of the verdict. CJI Deepak Mishra said adultery can be a ground for divorce but not a criminal offence. CJI Mishra and Justice Khanwilkar said mere adultery can't be a crime, but if any aggrieved spouse commits suicide because of life partner's adulterous relation, then if evidence produced, it could be treated as an abetment to suicide. The bench held that adultery can be treated as civil wrong for dissolution of marriage. Delivering its judgment, the Supreme Court said that unequal treatment of women invites the worth of the Constitution. The five-judge bench headed by Chief Justice of India Deepak Mishra said the beauty of Indian Constitution is that it includes the I, me and you. CJI also said that equality is the governing principle of a system and that a husband is not master of the wife. The CJI said Section 497 of Indian Penal Code is manifestly arbitrary the way it deals with women. Adultery might not be cause of unhappy marriage. It could be a result of unhappy marriage, the CJI said. Justice R.F. Nariman agreed with Chief Justice of India Deepak Mishra and Justice Khanwilkar to term Section 497 an archaic provision which is unconstitutional. D.Y. Chandrachud called adultery offence as a relic of the past and said Section 497 is destructive of women's dignity and self-respect as it treats women as a cattle of husband. Justice Chandrachud, in a section of judgment titled Good Wife, said in the most private zone choice is important for and sexuality can't be dissected from desire. Section 497 deprives women their choice about sexuality and hence it is unconstitutional. Justice Chandrachud added that a woman after marriage does not plead her sexual autonomy to her husband and depriving her of choice to have consensual sex with anyone outside marriage can't be curbed. Justice Indu Malhotra, the lone woman judge in the Constitutional Bench, too termed Section 497 as unconstitutional. However, Justice Malhotra said adultery is a moral wrong, contrasting it with Justice Chandrachud's view that each spouse in marriage don't mortgage their sexual autonomy to each other. Now I am going to discuss the judgment of Supreme Court on 497 of IPC in details. Husband is not the master of wives. Supreme Court struck down 158-year-old adultery law under Section 497 of IPC. The Supreme Court has struck down 158-year-old Section 497 of Indian Penal Code which criminalizes adultery as unconstitutional. Any provision of law affecting individual dignity and equality of women invites wrath of Constitution. It's time to say that husband is not the master of wife. Legal sovereignty of one sex over other sex is wrong. Section 497 punish a married man for having sex with wife or another man. However, the sexual act is exempted from punishment if it is performed with the consent or convenience of the husband of the other woman. Also, the provision exempt the wife from punishment and state that wife should not be even treated as an avator. The judgment of Chief Justice of India Mishra held that Section 497 violated a woman's right to dignity, resulting in infringement of Article 21 of Constitution of India. The judgment borrows from the finding of Justice Nariman's judgment in Triple Talaq case. The court, however, clarified that adultery would be a ground for divorce. It was also stated that if an act of adultery leads the aggrieved spouse to suicide, the adulterous partner could be prosecuted for abetment of suicide under Section 306 of the IPC. The judgment also struck down Section 198(2) subclause 2 of the Code of Criminal Procedure as a consequence of striking down of Section 497 of IPC. Justice R.F. Nariman wrote a separate judgment to concur with judgment of C.J.I. Mishra and Justice Khanwilkar and stated that Section 497 was an archaic provision which had lost its rationale. Ancient notion of man being the perpetrator and women being victim of adultery no longer holds good, observed Justice Nariman. It treats women as a cattle and has Calvinistic undertone. Justice Chandrachud, in his separate but concurring opinion, said that Section 497 was destructive to women's dignity. Autonomy is intrinsic in dignified human existence. 497 denounced the woman from making choices. The law in adultery is a codified rule of patriarchy. Society attributes impossible attributes to a woman. Raising women to a pedestal is one part of such attribution, he said. Respect for sexual autonomy must be emphasized. Marriage doesn't preserve ceiling of autonomy. 497 perpetrates subordinate nature of women in a marriage. These were his concluding remarks. Justice Indu Malhotra noted in her judgment that section institutionalized discrimination. Background of the case. The 4-day-long hearing in the PIL praying for the decriminalization of the act of adultery had witnessed positive feminist remark from Supreme Court 5-judge bench. The argument against you, the petitioner, is that Section 497 protects the security of marriage. However, if a married man has sexual intercourse outside his marriage but with an unmarried woman, that doesn't amount to an offence under provision, though it also affects the sanctity, reflected Justice D.Y. Chandrachud. Fidelity doesn't apply to married men if he engages in an extramarital sex with a single woman. You exact fidelity from a woman but not from a man, he asked. Concluding Justice Rohinton Nariman cited the classical Article 14 test, where is the intelligible differentia in saying that the sanctity of marriage is not hurt if a married man has sexual intercourse with an unmarried woman. This is manifest arbitrariness. Further, Justice Chandrachud indicated the imperative of the section insofar as it exempts from criminal prosecution a man who has engaged in sexual intercourse with a married woman if the same transpires with the consent or connivance of the said married woman's husband. Can the section be saved if we strike down this part? Because this is one ground for the unconstitutionality of provision, or would we, by applying the doctrine of severability, in fact make the offence even more severe than the legislature intended? Beside consent, if the husband of the woman connives with another man for later to participate in sexual intercourse with the former's wife, then there would be no adultery. This connivance attaches a certain deviousness to the act. He continued. Justice Indhu Malhotra also pointed out absurdity of the section in as much as it legalized the act of adultery if committed by with the consent or connivance of the husband of the woman who is party to the act. Is the wife of consenting husband being treated as a chattel? This amount no gender views. The provision in anti-human in a very ostensible way insofar as it implies that a woman could be subjugated to this extent on the consent of her husband. This is unknowledgeable to Indian thought. This is unknowable to Indian thought. Such consent or connivance is unacceptable, observed Chief Justice of India Deepak Mishra. Section 497 of IPC, insofar as it absolutely immunize the adulterousness against any criminal prosecution for the act of adultery, was also canvassed. There is no rationality in treating one party as victim and the other as accused for the same act. The only rationale behind the provision seems to be that marriage is an institution which has to be served. Marriage has been called an institution in all scriptures. It is built by two pillars, and there has to be equal responsibility of both. To say that women are protected from the criminal ramification of adultery under Article 15.3 is not justified. Article 15 subclause 3 only applies to post-constitutional laws, noted Chief Justice. An ancient provision is not protected under Article 15 subclause 3. It is for the Parliament to make laws under Article 15 subclause 3, agreed Justice Nariman. It was also pointed out how Section 198 Section 2 of the CRPC allows the initiation of criminal proceedings for adultery only at an instance of the husband of adulteress, but the wife of the man party to the act of adultery can't institute a complaint. The man shall be booked for the offence and his wife shall suffer, but husband of the woman who has committed the crime will have the benefit, observed the Chief Justice. Referring to the offence of bigamy under Section 494 of IPC, Justice Chandrachud weighed in. Bigamy is a gender neutral. If a woman engages in sexual intercourse in a second marriage while the first subsisting, it is punishable. Section 497 does not use same the yardstick as Section 494, and this distinction makes the former unconstitutional. The judge also remarked how sexual intercourse outside a subsisting marriage may be a symptom of a broken down marriage. If a marriage has broken down and party engages in sexual intercourse outside the marital tie, you cannot criminalize that person. However, the sexual autonomy inherent in us is not absolute, and that adultery is a ground for divorce is a reasonable restriction on that autonomy. Discriminalizing adultery would not have the effect of licensing it, noted Justice Chandrachud. He repeated that one retains their sexual autonomy to an extent even after marriage, and that right to say no is not forfeited by marriage. Toward the end of hearing, Justice Chandrachud weighed in the making of Section 497 gender neutral would only address the issue of under inclusion, and that the real question is if adultery should be a criminal offence at all. Justice Malhotra voiced her skepticism about how the relationship between two adults, which is matrimonial dispute, could be a crime against the society. Why the Chief Justice observing that the survival of a marriage should be left to the discretion of husband and wife without any intrusion by the state, the judgment was reserved. So this much for today, and please don't forget to subscribe our channel Law Mantra for more legal updates. Thank you.